Hi, everyone. I'm Megan Zimba, the Educational Chair of Women of Today's Manufacturing, an organization that supports the creation and advancement of career pathways for women in local manufacturing. I'd like to welcome you to another episode of our WOTM videocast. Today's topic, how Illinois manufacturers are adapting to the legalization of marijuana. At the beginning of the year, Illinois became the 11th state to legalize the sales and recreation use of marijuana for adults. The HB 1438 Cannabis and Regulation Tax Act was passed by the state legislature on June 6th of 2019 and then signed into law by the governor on June 25th of 2019. For Illinois manufacturers, this has raised some concerns. Definitely in regards to safety and productivity. So I would like to introduce our special guest today, Mary Jo Reynolds, who will shed some light on what manufacturers should know and do to keep the employees that they have safe and productive. So welcome, Mary Jo. Thank you for taking the time to join us today. Before we get into the questions, can you just provide a little information about yourself and what you do in regards with this new law?
Certainly. So it's my pleasure to be here this morning. Thank you for having me. I am Mary Jo Reynolds. I'm an attorney with Hinshaw and Culbertson. I've been practicing in the area of labor and employment for about 8 years now and routinely counsel employers on a host of legal matters, particularly regarding compliance with new or with changing statutes and regulations, one of them being in connection with medical and recreational marijuana. I have the pleasure of working with a lot of manufacturing clients, and as you mentioned, they, like all employers, are concerned about safety. They're concerned about the safety of their employees, in some cases their patrons, their customers, and they want to know what changes need to be made to their policies in order to comply with this new statute, and then how that translates to changes in terms of testing or in terms of standards being applied to employee conduct.
So you really just provided a simple answer for the first question that I had for you on what some of the concerns were with manufacturers in regards to this new law. So one of the main things is like safety, and I'm sure they did have a lot of questions about their policies. So in regards to their current policies, what are some of the things that they need to know about either changing or adding to their current policies? And does that affect what they have set up for their testing policies? And if so, how does it affect that?
Sure. Well, on the topic of safety, before we dive into policy specifics, I think it's important to note that the Illinois Cannabis Regulation and Tax Act includes language at the beginning that reads as follows. The legislature states, the General Assembly supports and encourages labor neutrality in the cannabis industry and further finds and declares that employee workplace safety shall not be diminished, and employer workplace policies shall be interpreted broadly to protect employee safety. So I think that's good news for employers and particularly for manufacturers in terms of priorities, and the legislature is clearly indicating that workplace safety should remain a priority. We have not yet seen litigation regarding this new statute, and so time will tell how courts will interpret it. I suspect there may be a little bit of an evolution on the acceptance of recreational cannabis, but for the time being, in light of language that I just read, and particularly in light of what we call a trailer bill that was added onto the statute after it was initially enacted in June, there was a trailer bill added in early December that really clarified things for employers and addressed some open questions, particularly regarding pre-employment testing and random testing. And the bottom line is that at this moment, we feel pretty confident that the statute is relatively employer friendly, and it is permissible for employers to kind of continue with the status quo in terms of having zero tolerance policies and enforcing them, and maintaining drug-free workplaces. This can be of particular importance for any employer who's a state or federal has state or federal contracts with the government, because there's also some federal and state laws called the Drug-Free Workplace Acts that the employer has to abide by. And so there's what I like to refer to as a patchwork quilt of legislation that's very confusing, because cannabis is still a Schedule I drug, making it illegal under federal law, the Controlled Substances Act, but now, as we know, it's become legal under state law. And oh, by the way, there's these, Drug-Free Workplace Act that certain employers have to abide by, as well as some other considerations under OSHA. So it is a confusing landscape for employers, but I think the good news is, whilst there should be some policy changes, the overarching, zero tolerance standards and drug-free workplace requirements can still remain in place. And in a way, testing can continue as it always has, and discipline can continue as it always has, at least for the time being.
So what sort of changes should they consider with their current policies or additions in regards to maybe make the language a little bit more clear for their employees, so that their employees can't come back and say, well, it's legal in Illinois. How can they react to that situation so they're not getting in trouble?
Yep, that's a great question. And I think, it's important in light of this new statute that all employers, particularly manufacturers, review their policies. And, you may want to talk with someone from your occupational health or your insurance provider, and, touch base with them in terms of their expectations, their recommendations. This can vary by industry, but what I'm seeing amongst my manufacturing clients is they kind of want to continue with the status quo, and consequently they should make the following changes to their policies. Most policies that we see come across our desk refer to a prohibition of illegal drugs and alcohol, but that can be a little confusing for an employee in light of the fact that cannabis is now legal under state law. So I'm recommending that my clients break out cannabis and address it separate and distinct as a prohibited substance. So instead of having a policy that prohibits the use or sale or transfer, etc., of illegal drugs and alcohol, your policy would now refer to a prohibition in connection with illegal drugs, cannabis, and alcohol. I think that's a helpful clarifying distinction. It's also important to look at the testing language in your policy. And I recommend that all clients update their reasonable suspicion testing standards to add language from the statute, because the statute lists a number of what they call articulable symptoms that can merit good faith reasonable suspicion testing. And so it's helpful if your policy includes a list of those symptoms, when you can say including but not limited to, it's not an exclusive list, but it would be helpful to cite the language of the statute to set employee expectations, and if you ever had to, defend against conducting a reasonable suspicion test. The same goes with post-accident testing. This should be reviewed and potentially updated, not necessarily under the new Illinois Cannabis Regulation and Tax Act, but under some OSHA regulations that were updated in October of 2018 that talk about who should be tested and the circumstances and the potential contributory behavior that might merit post-accident testing. So, number one, break out cannabis and address it separate from illegal drugs. Number two, look at your testing language, particularly reasonable suspicion and post-accident. Number three, and this is an important one, add in language in your policy about an opportunity to contest. this may seem, kind of something that gives you a little bit of pause as an employer, because, you may not normally want to give your employees a chance to contest a positive drug test, but the statute actually requires that you do so in limited circumstances. So the new statute says you have got to give employees who test positive for cannabis or are discharged in connection with suspicion about the use of cannabis a chance to contest. And it's a little unclear exactly who needs to be provided with the chance to contest. For sure, you need to give it in connection with reasonable suspicion testing, but I think it's a best practice to give it across the board. And so even if you're doing pre-employment testing, if you have a candidate for a position that tests positive for cannabis, allow them to, quote unquote, contest the finding in writing. Now, just because they do that and they basically are given a chance to tell their side of the story does not mean that you need to accept their side of the story and look the other way. You can still discipline them or choose not to hire them and enforce a zero tolerance policy. In fact, if you have a zero tolerance policy, that's recommended. But nevertheless, the statute calls for the provision of this opportunity to contest. And so you need to make sure that your policy complies with that requirement.
Now, in terms of, recreational cannabis and medical cannabis, is there any language in their policies that they need to be aware of, especially with suspicion testing or, random testing? I mean, if manufacturers have a zero tolerance, then that probably, means zero medical marijuana as well. But any policy that doesn't have that zero tolerance included in the policy, what's some of the differentiation language that they need to include to, define medical versus recreational?
That's a great question, Megan. And there is a distinction between medical versus recreational cannabis. How I recommend my clients address medical marijuana is to simply add a cross-reference to their accommodation policy. And although not necessarily required under Illinois law, I think it's best practice for employers to take an employee who is a certified card holder for the use of medical cannabis and to engage in that interactive process, to have a dialogue with them and say, okay, these are the essential duties of your job. Can you meet them? Answer probably no. Is it reasonable for us to accommodate you? And an example of an accommodation might be a temporary unpaid leave of absence while the employee needs to use the medical cannabis. The answer may be no, that may be an undue hardship for the employer. And so the outcome may be that it's not permissible for the employee to use medical cannabis, and they can't continue their employment because they can't do the essential functions of the job. And it's an undue hardship to accommodate that. But I think it's probably best practice, especially since, we don't have a lot of guidance from the courts, and we've seen other states come down on the side of, a necessity to engage in a reasonable accommodation interactive process. So I think proceeding like that under an accommodation policy makes sense. I also, see a lot of policies and think that it's best practice for employers to tell employees, listen, the onus is on you. If you're taking any medication, over the counter, prescription, medical cannabis, anything that would impair your ability to safely perform your essential duties, tell us, and then we'll talk about whether we can accommodate that. What you don't want to do is have an employee test positive after the fact, because there was reasonable suspicion, and then be dealing with these things on the back end. It's better to be proactive, put the onus on the employee to bring it to your attention, and try and address it on the front end. Medical cannabis, is an area that of concern for a lot of employers because there's simply not a lot of guidance. We know definitively you can't discriminate against a card carrying medical cannabis certified card holder. You know, we know the list of conditions that might qualify. You know, the reality is a lot of physicians in this region don't seem to be certifying patients for medical cannabis. So, you know, while this does come up, it doesn't come up with the regularity that some employers fear it might. But nevertheless, adding that cross-reference to the accommodation policy, you know, would be best practice. And I should note that regardless of recreational versus medical, you know, any drug policy you have has to be applied in a non-discriminatory way. And, you know, that simply means you can't say, well, I'm going to drug test all my female employees, but not all my male employees, or, you know, anything of that nature.
Okay. In terms of information, like identifying someone under the influence, training staff or management, and ways to approach employees and updating their policies, what are some of the resources available for employers? Where can they get this information?
That's a good question. You know, I think everything boils down to good communication. You know, I think if you're going to have a zero tolerance policy and enforce that, you should be clear with your employees that that's the expectation and that is still legal under Illinois law. In terms of like secondary resources, I think the best thing to do as a starting point would be for employers to actually go to the statute. The statutory reference is 410 ILC 701, and the article that is of interest to the employees, or I'm sorry, to the employers, is section 1050, and that's the section that addresses employer considerations and includes the trailer bill provisions. I think it could be helpful if employees have questions to direct them to the statute. I know, you know, sometimes reading a statute isn't that user friendly. There are not regulations, you know, thus far. I'm not necessarily aware of secondary sources, but I know that there are HR seminars that address the topic of cannabis. I have conducted trainings at some of my clients' facilities regarding the topic of recreational cannabis. And, you know, there are subject matter experts that are more than willing to lend their expertise and be of any assistance, you know, desired.
So if they need any sort of legal counsel, would they be able to reach out to your firm, or, you know, what other resources are there available for legal counsel?
Oh, most definitely. There's a lot of great attorneys in this region, a lot of great law firms. You know, a lot of employers already have a standing relationship with an employment counselor. And, you know, if you already have that relationship, they likely know the background of your business and information about your, you know, your priorities. And so it may make sense to certainly stick with them and to inquire, you know, their thoughts on this and have them review the policy and, you know, potentially conduct a training. So I would say this is a topic that was getting a lot of buzz. And so I would venture to say that most of the labor and employment attorneys in our community, you know, are very up to speed and well versed on this topic.
Well, is there anything else, Mary Jo, that you would like to add to the conversation that we haven't touched on for today, or do you think that we covered a lot of it?
I think this was great. You know, I will note that one of the things that created confusion last summer when recreational cannabis became legal was an amendment to the Right to Privacy in the Workplace Act, which is a statute that says employers can't discriminate against an employee for using a lawful product outside of work, for example, smoking or alcohol. And to the list of lawful products was added recreational cannabis. But what people overlooked was the beginning of that sentence that was amended in the Illinois Right to Privacy in the Workplace Act. And that sentence said, except as otherwise provided by law in Section 1050, the section addressing employment of the Cannabis Regulation and Tax Act. So essentially, the amendment to the Right to Privacy in the Workplace Act clarifies that the employer provisions of the Cannabis Regulation and Tax Act trump the amendment to the Right to Privacy Act amendments. And so I think there was confusion because people thought, oh, well, now it's a lawful product. My employer can't prevent me from using that. But the legislature, I think, in the way that it made the amendment, clearly cross-references the employment section of the Cannabis Regulation and Tax Act. And that is really what is the meat and potatoes of this analysis. And so that, again, is helpful because it clearly promotes employer workplace safety. It clarifies that, testing for the most part can continue business as usual, as can discipline, as can enforcement of zero tolerance policies. So I think all in all, this is good news for employers. I just encourage you to review and update your policies to make sure they're in line with the new statute.
Well, thank you, Mary Jo, for taking the time out of your day to share your information with us. It was really helpful. I'm sure it's going to help a lot of manufacturers, and we appreciate, taking the time out of your busy schedule. Being an attorney, I'm sure you have a lot of work going on for you. I also want to thank everyone out there in our audience for joining us on another video cast. If you are looking for more information on our organization, the WOTM, please visit our website at www.wotmrkfd.com. Thanks again, and everyone stay safe and healthy. Cheers.
Thanks for having me in WOTM. Thanks for the great work you do for the community.